We're going to talk about dependency and indemnity compensation. So if you remember from hour one, and I don't fault you if you don't, but these are the other two types of claims of the three that I mentioned. We're also going to talk about the requirements to represent veterans before the VA. So we're pretty heavily regulated, so you have to follow VA's requirements. There's no not being accredited and collecting a fee or any of that stuff. So we'll talk about that as well. Although first, non-service connected disability pension. So I work with a lot of homeless folks, and I love this. This comes in handy a lot. What this is for veterans who are totally and permanently disabled. And you'll notice the non-service connected part, they're just totally and permanently disabled. It doesn't have to be due to things that happened in service. So there's a couple conditions to be eligible, and we'll go over these in more detail. Has to have an eligible discharge. We won't go over that in more detail because that was hour one, but you're going to check the discharge papers, make sure the person has good paper. Served during a wartime period. Sadly, that's most people. Meets the minimum duty requirements. Has a total and permanent disability, not due to willful misconduct, and is low income and has a net worth which does not provide adequate maintenance. Basically, he's poor. Oh, and I should add, there's the note at the bottom. Pension is needs-based. So it's pension or service-connected disability compensation, not both. They get whichever one's higher. They don't get both. And we'll go over that a little too, about what it means to be needs-based. Okay, first let's do the wartime periods. These are the wartime periods. So when I was saying that's most people, I only did the ones that you might actually have someone stumbling into your office. I will say I realize I have World War II on here. Believe it or not, I actually had a veteran come in one day, came motoring on in, sat down in the chair, gave me his papers. I almost spit out my coffee when I saw his birth date. He was in his 90s. He was actually a World War II vet. So could happen. And I think he's still around, actually. But these are the wartime periods. The hardest is when you get the guys that serve between 75 and 90. You'll run into those periodically. There's no saving this for those guys. If they didn't serve during a wartime period, they are just not eligible for this. Okay, these are the service requirements. They must have had active services either 90 days during a period of war or 90 consecutive days, one of which was during a period of war, or at least 1 day of wartime service, and the veteran was discharged for a service-connected disability. For folks who enlisted after 1980, they must have served 24 months of active duty, or the full period for which they were called. And you're going to think National Guard, the full period for which they were called. If they're only called for 3 months, that's fine. They don't have to have done the 24 months. Okay, this is a big one. These are needs-based benefits. So the vet, when I'm looking at these folks, I'm usually looking at guys in homeless shelters. So it's not an issue. There's not any income coming in. But if there's income coming in, say they're getting Social Security and for whatever reason it's only like $500 a month, they would qualify. But if they're getting any income, it has to be less than the $12,907 per year. So they can't have a lot of money coming in. They can have basic necessities. They can have a house, they can have a car. They can't have 2 houses, they can't be renting a house, they can't have 2 cars. They have to keep it down. It can just be basic necessities only. Oh, and as I put here, if there's a spouse, it has to be, income has to be less than $16,000 a year. And they can deduct medical expenses as well. Okay, here's the great news. The disability can be due to conditions acquired at any time. They have to be unable to work. It's assumed that veterans 65 and older meet these conditions. They automatically can get the pension if they meet the rest of the criteria. And if they're in a nursing home receiving skilled nursing care, they can also get it. I want to flip on to the next slide. So one of the things I'll do too, it's changed a little. So you've probably heard the bad press on VA moving too slow and how they're supposed to be adjudicating things quicker. Well, they are for initial claims. So I will still do this, but now it's kind of a toss-up who decides it first. It used to be I would always apply folks for the VA pension and Social Security's disability benefits, usually SSI, at the same time, because the SSI would come in first. And the only reason I would do that is SSI this year only pays $750 a month, and this program pays almost twice that. So they'd get the SSI, they could live a little bit for a while, they'd get the pension, they could live better. Now it's kind of a toss-up on who gets it first, but I'll still apply them for both, because whichever one comes in first for my homeless vets is going to mean housing. It's going to mean getting out of the shelter. But the great thing too is the disability findings made by the Social Security Administration. I'm saying the great thing. VA is supposed to use these and make an identical decision. It doesn't always work perfectly. I see you nodding. It really doesn't always work perfectly. It's supposed to. Luckily, the folks up here in Honolulu VA are pretty receptive, so you can actually talk to them and say, hey, I've got this Social Security disability decision, and you can explain to them what it means and get it fixed when it doesn't work perfectly. But the way this works, so VA is going to look at the veterans' disabilities. They're going to look at their schedule of ratings. So this means you're still looking for the 250%. Whatever the veteran has going on, they're going to see if they had rated everything under their schedule of ratings, if it would equal 100%, or if it would preclude the individual from working. So you're still going to need either the 250% or something that really establishes that this person can't work. Part of the good news, the stuff that you can't get service connected, you can throw in here. You can't throw in the drugs and alcohol. Drugs and alcohol are still out. That's willful misconduct. But personality disorders, intellectual limitations, birth defects, all that can go in here. Then the last thing I want to show you are the payment rates. And here's what makes the non-service connected so valuable. So I know I was talking about SSI. For our civilian folks in the same situation, their option is SSI disability. And that's $750 a month. It doesn't go higher with dependents, none of that stuff. So for veterans, this is what we're trying to ultimately angle for if they qualify, if they meet all the rest of the criteria. A single vet is going to get $12,907 a year. With one dependent, it's going to go up to almost $17,000. It's going to go up over $2,000 for each additional dependent. If they're housebound, if their condition leaves them housebound and they can't leave the house, it's going to go up to almost $16,000 a year, and that's with no dependents. If they need aid and attendance from another person, they need someone else helping them out. With no dependents, they're going to get over $21,000 a year. So the price differential on this is huge. The access to services on this is hugely different than what civilians have. So when you run into those folks, and we've got a ton of them, when you run into those folks, the veterans who are poor and who served during a wartime period and who are totally disabled or are over 65, this is a great program to get them applied for. And what really surprises me is I've sat in the shelters before and I've run into vets that haven't heard of this. So even if you're just talking story to folks, if you run into these folks, send them up to VA to apply for this, because this can really change their future for them. But anyway, that's non-service connected disability pension. John is going to go over dependency and indemnity compensation.
Okay, thank you, Diane. Okay, so this is really a useful program. This is for the spouses of veterans who pass away. Let's see if we've got the right slide up here for us. Yeah. So for DIC, we call it DIC, these are benefits paid after vet's death to a surviving spouse or the dependent children, including stepchildren, and they do not have to be adopted to be eligible. Spouse must have been married to the vet for at least 1 year prior to death, and that's a key, a 1 year window. Vet's primary or contributing cause of death was a condition that was service-connected or can be service-connected after death, and I have seen that. I've seen a spouse that came to my attention, I think 7 years after her husband's death. She was a person with limited English speaking, and without giving away the exact facts of that case, you might see a fact pattern someday where a spouse will come to you and say, well, am I eligible for benefits? I don't know what my husband had. So what you'll do is you'll research the file. You'll get a release, you'll research those records. And if you find that a veteran died of a condition that he or she was service-connected for, well, you can apply for DIC for that spouse even years later, and I've done that. So that's really a neat thing. And with service members, you're going to see this because sometimes service members will marry a fine spouse in Korea, Japan, or other places. Maybe they have limited English speaking. Philippine spouse as well. Not just to stereotype those people, but you will see those ethnic groups married to service members. And some of those dear people may not have as much English speaking ability as you do. So you'll read the records, you'll take a look at the VA decision, and you may well get that spouse some good relief. So that's a really important thing to remember. Can be service-connected after death. That's really an important point. Veteran had 100% service-connected disability for 10 years prior to death, or died of a service-connected condition, one or the other. The good news is if you're a 100%er, and 100%ers ask me this all the time, they're 100% total and permanent disability. They say, how long do I have to live? And of course, they're struggling with things like cancer and other conditions. If you're dealing with Vietnam vets, which I do day in and day out, they're wondering how long they can live in the aftermath of prostate cancer, especially when it comes back. Will they survive lung cancer? That's another presumptive, and so on. So the 10 years, in fact, in that case, if they die of a service-connected condition, they're fine. But the 10 years, they could die of anything, unless it's a self-inflicted condition. Okay, DIC rates for a survivor without dependents 2017 start at $12.57 a month. This amount increases for the following. So at time of death, vet was totally disabled for 8 years prior to death, overlapping 8 years of marriage. That'll add another $267 a month. That makes it a little more survivable. Many of us are arguing, and nothing's happened yet, but we really feel these rates are just totally inadequate for a spouse. But that's what we're able to get at this point. So $1,200 a month, who can live on that? Anyway, it'll get it up to 14 if they were married 8 years and they had 8 years overlapping total disability. With dependents, you'd add $311 a month for each dependent. If the surviving spouse is housebound, you can add $145 a month. If they pass the test for the need of regular aid and attendance of another person, that'll add $311. Skilled nursing home. Survivor should file an app, VA 21 535 ARE within 1 year, so that benefits go back to vet's death. And claim for Social Security survivor benefits would also suffice. So really, as soon as that vet dies, we like to tender a claim for DIC immediately. And the things you have to have is you've got to have a death certificate, and typically you need medical records. I like to put together what I call a fully developed claim. And I encourage you to do that, is have all the data that VA needs so you can lead the rating person straight to where they need to go. And at least here in Hawaii, I can tell you, the VA, the benefit side, really the raters want to find. So if you can do all you can to give them all the data they need, they'll find for you if you've got it. So I say submit your packet with everything, death certificate, med records, claim, and of course your 2122A, which is your power of attorney form, and that's going to be essential as well. Okay, now let's take a look here. In addition to other payments, if vet had been entitled to but not paid VA benefits before death, surviving spouse can be paid those accrued benefits. Now that's important. I just got an appellate decision back after a couple of years from BVA. We'd waited a few years to get before the judge. A couple of years later, we did get the decision. Spouse got accrued benefits. I think they got about $29,000. That wasn't a lot, but it was something. So that's really a bona fide case, accrued benefits. Spouse, this is a key. Spouse can substitute for the vet to argue his or her claim. A note here, as of 2016, spouse is no longer limited to evidence that was in vet's claims file at the time of death. Initially, we were bound by the evidence in the C file at the time of death. That really is problematic because there's a lot of other evidence that we really should have been able to bring in. Now we can't do that. And I've fought several of these cases. Generally, this is in the appeals venue, generally. And fact pattern will go something like this. You're representing a client, and with Vietnam vets, and we've still got a host of them alive, thank God. But with Vietnam vets, they have typically terminal conditions. And you're in the appeals arena, and you're arguing, for example, a veteran was in the Brownwater Navy. Now that's a term of art, if you will. The criteria for a presumptive Agent Orange connection for Vietnam veterans is they had boots on the ground, okay, in Vietnam. It can also be problematic for even a man or woman who was boots on the ground because some services did not always acknowledge service on the ground in Vietnam. We won't really get into that too much, but those can be appellate issues. So you're dealing with a person who is in the process of dying, effectively, and you're in an appellate process that might last for years. The idea of a substitution of the spouse is really important, and you want to file that as soon as possible. There is a time limit, so as soon as you learn of it, you're going to file. Now, when I say there's a time limit, I can't tell you the precise one off the top of my head. It's less than a year, I think. But I want to commend you to the LexisNexis Practitioner's Manual, because I just thought of that. Every day I look things up in that manual. It's my survival guide. It's about $150 for the LexisNexis manual, another 100 and some for the statute manual. That's a desk book. I mean, you will use it every day as a practitioner. I know this gentleman back here has one. He uses it, and Diane and I use it. I've got counselors all over these islands with the Office of Veteran Services. I've got a manual for every one of my counselors. And when they call me up, or if you call me up someday, I'm going to ask you about the fact pattern, and then I'm going to ask you, what does the manual say? And show me where you found your answers in the manual if you want to talk about it. And I will tell you this, it's just like law school. Sometimes I have to read that manual section 2 or 3 times. You know, 'cause there's a lot of nuances to this stuff. So it's really cool. That's what we do with statutory analysis. That's what we do with case analysis. That's what we do with the LexisNexis manual. I commend you to that based on this. What's my time limit? We'll find that in just a few minutes in that manual. Okay? Yes?
Is it only the spouse is limited to only the spouse, or like if the...
Surviving minor child.
Yeah.
Yes, surviving minor child can do it as well.
Okay, great.
So it's just like the DIC people. And that's an outstanding question.
That's me.
Okay, Diane.
I will say disabled adult children too, but that one's
That's
more
right,
common.
disabled adult children.
So these are the requirements to represent veterans. So like I said, we're highly federally regulated. Apparently attorneys used to represent veterans in the 1800s, and VA and Congress exited us from the practice. Someone was misbehaving. I'm sure that's not hard to understand. And we weren't allowed back in until 2008. Up until 2008, you could represent vets. The most you could charge was $10. In 2008, they changed it in Congress. There are still moves in Congress every year to change it back, not by vets. But there's still a little infighting about it. But we've been able to represent vets since then for pay. But we're heavily federally regulated. And one of the reasons I tell you all this, is even today, like it's been almost 10 years at this point, and even today, sometimes I'll still run into folks. John will even watch me still run into folks that really feel like attorneys should not be in this practice. So just be prepared for that. Follow this to the letter, just so you don't have any problems with VA. Before you can do anything with a veteran, and the crazy thing is, I've seen VA have people do this just to do a free help desk. So we had a bunch of young lawyers in our bar association who wanted to work with vets, and VA said, well, we're not going to let you work with vets until you all get accredited. So to be accredited, you definitely have to do this if you're going to do disability claims. Fill out the VA Form 21A, send it to the VA Office of General Counsel, and then wait for word that you're accredited. I'm not sure how long it's taking these days. For anyone that's recently done it, you probably know, but I'm not entirely sure.
A couple of weeks.
Oh, is it? Oh, thank goodness, because for a while there, for me it's like a couple of weeks, but for a while it's taken over a year.
It can actually take overnight.
Oh, awesome.
But what you should do is, if you're barred, send them a copy of the bar. I think that's what really slows it down. They get you researching it, so it's a copy of the bar certificate. And just kind of like I can send you an email the next thing.
I'm just glad to hear they've gotten better, because for a while there it was really bad.
You can email to them.
Of course, you also have to take the 3-hour CLE, and that's this morning.
Can I put in a plug for trip training?
Oh yeah, go ahead.
There's a thing that the VA has called trip training. It's training in responsibility for cases, effectively. It's like, I think for attorneys, you only have to study like 5 chapters out of 18. It's a pretty good deal.
Oh, they still make you do the whole thing.
No, I've got email that indicates 5 chapters, but
Oh, they make
even
me
if you
do the whole
do,
thing.
even if you do read the 18, it's actually useful data. But if you take VA trip training and it's self-administered, you don't have to go to a class, you don't have to take an exam, and I can help you set that up. If you take that and you jump through the VA's fairly simple hoops, then you'll be able to access the VA claims file, the electronic claims file. And I recommend that you do that if you practice in this area, because it's going to save a lot of aggravation trying to get discovery to say, well, you know, I'm entitled to see this records. I need a copy. Well, you know, you can have read-only access to that entire record electronically if you're trip trained. And of course, if you have a 20 and 22A on file for your specific client. So I commend you to that, and I will help you get in touch with Eric Gaskin of Public Contact at VA, who will be pleased to help you. And Glenn Marumoto is your real point person there at the VA, and he is outstanding, and he loves working with attorneys and with VSOs. So I commend you to those people. They're very decent folk, and they will help you immensely.
It will also help you for anyone who doesn't have access to Tripler. It's sort of odd how they do it. So I've done the trip training. I have access to the VA systems. I actually have a VA ID card. It specifies I'm an employee, and they actually have me down on their rolls as an employee, which I know because I've been asked about it from my clients. It's odd. It's odd. But it does for those who don't otherwise have access to Tripler. It gets you on and off that base, and you can go in and out of VA. And it also gets you in and out of the files.
Yeah. And when you got to get up the hill for a hearing, it's nice to have that ID card. You go right in, and you've got access to your hearing room and things. So it's good to really have access to all that and be on good stead with the VA, just in terms of they know who you are and you've taken their training, Privacy Act stuff as well. It's really cool.
It tells VA that you're not just a fly-by-night, you're not just looking to make money off the vets. I mean, we still do have this stigma following us where some of the folks really don't like us. And I'll say it's been to the point, gosh, it's been 6 or 7 years now, but I had someone chewing me out in VA, you know, behind the locked doors on the benefit side, a VA employee, about how I was just looking to take their money. So it's been that bad before. Yeah. And there are still some vestiges of that. So the more you can show that you're doing this because you care about vets, the better.
And I can say this, the VA management, from the VBA director on down, all the managers, you know, all the line staff, the supervisors, they are all very decent people here in Honolulu, and they are definitely motivated to work with attorneys, and I assure you they will treat you with dignity. If there is any issues you have and you need my assistance, I can bring you to the XO up there and we can talk about it with them, and I've done so, as Diane can say. So if you have a problem, I will assist you, but I don't foresee that you will have one.
So I will say, getting on with the requirements to represent vets, to keep your accreditation, you have to annually send certification of good standing and any other information for every jurisdiction to which you're admitted. I have found that simply giving them a letter saying that I'm in good standing, that it hasn't changed, will actually suffice. I don't know that I should say that, but the certificates cost money, so if you don't want to be shelling out, and especially, I'm a military wife, so I've lived in a couple different states, so if you don't want to be collecting them from all over the US, so far a letter has sufficed. And then biannually, you have to certify to VA that you attended 3 hours of CLE on any topic of Veterans Benefits Law and Procedure, and of course, this suffices for that as well. And that's just the minimum requirement to represent veterans. So at this point, with all that done, you can represent veterans, but you're not actually representing a veteran. So to represent a veteran, you have to enter into a Form 2122A. So this isn't your fee agreement. This is just their form to show them that you are repping this vet. So on this form, you want to put your scope of representation. John will go over all the different places we can rep vets. On the 2122A, exclude the courts that I don't intend to go to. We can go as far as the Supreme Court. I just specifically exclude it so there's no question later should this vet keep going whether or not I'm going to appear. So you want to put down your scope of representation. I will often put down what I'm representing them for. I will say, one of the things vets can do, so you agree to rep them for, let's say, PTSD and a bad back, and your client's up at VA, and he puts in 5 more claims. All of a sudden, you're representing him for 7 claims. So one of the things I'll do is actually specify on this form what I'm repping the vet for. It doesn't mean that VA won't assume that I'm also representing him for the other claims, and that usually requires a conversation with the vet. So just word to the wise. But I'll at least put it on the form what I understand our representation to be, and if I didn't want to represent him on those other 5 claims, VA couldn't hold me to it. Theoretically, I've heard from other attorneys this has worked in other jurisdictions. I've only tried it once here and it didn't. Theoretically, different agencies can represent veterans for different components of his claims. That's a hard one to pull off with VA, so do understand if your vet goes up and puts in 5 more claims, you're not necessarily on the hook to represent him, but it does mean that he probably can't get representation from someone else. And to avoid that, it's always best to have a conversation with the vet first and say, this is it, right? Not that that will be, but let's see. Oh, and then of course, submit the form to VA up on the Hill. So submit the form to the Honolulu VA. Okay, and here's if you plan to charge a fee. One thing that's changed that I didn't manage to take off the slide in time, you no longer have to submit the fee agreement to the Office of General Counsel. You just have to submit it to VA up the Hill. So you can only charge a fee on an appeal. So all these initial claims that we're talking about, filing the first claim, you can't charge a fee. You have to do it pro bono. It's one of the regulations in VA. They also regulate how much you can charge. So if you charge 20% or below, you can submit it to VA and ask that they do the calculation. What they'll do is they'll calculate, provided you win, they'll calculate the 20% of what they owe the veteran from the past. They'll dump that 20% in your bank account because you'll have given them your bank account information, and they'll send the veteran the rest. So you don't have to send a bill. You don't have to worry about it. VA gives you your portion, they give them the rest, you're done. If you decide to charge more than 20%, they won't do that. You can charge up to 33% without them denying your fee agreement, because they also have to approve your fee and your fee agreement. And you can charge up to 33%. You won't be able to charge more than that. They've pretty much decided across the country that more than that is not fair to the vet. You can tack on out-of-pocket costs, medical records, if you do send them to an outside doc, those sorts of things. Of course, you have to submit your fee agreement to VA up the hill because they're the ones who are going to adjudicate whether or not you can be paid. And this includes even if you're not going for them paying you directly, they have to see your fee agreement, because if you charge a fee and you haven't submitted your fee agreement and they haven't said this fee is okay, you're in trouble. You won't be representing vets again. I think that's all we have there. Does anyone have any questions about the fees? I will say that's gotten better too. I hate to be the bearer of bad news, but in the beginning it was really hard, as in half the time VA wouldn't pay the fee either. They have to approve the fee agreement, and either they just wouldn't pay it or they would find all kinds of reasons why they didn't have to. And that's gotten a lot better too, but you still have to keep an eye on it. VA here is fine. I've talked to them extensively. They're fantastic. But sometimes they'll ship the claims out to other jurisdictions, and I still have one sitting in Seattle that they've never paid me on. So in that, you have to get the fee agreement in pretty quick. It has to be in within 20 days after you sign it. And in that, they hadn't uploaded it in the system. They had it within 20 days, which I could prove, but they hadn't uploaded it in the system until the 22nd day. So we're still fighting over whether or not I get to have the fee. Anyway, this hour we got done a little bit early, and that actually works well, because the third hour is going to be a lot of intense information on how to file the claims. It's the nuts and bolts. It's all the places you file the claims and the appeals and all the places you can go with these claims. So I suggest you shake it out on your 10-minute break, because you're going to need it.